The Cybercrimes Act 2020, what does it mean for your privacy? Now, cybercrime is on the increase in every aspect of life. Hardly a day goes by without a news item about the latest ransomware attack. But there is one type of cybercrime that is decidedly egregious: cyber abuse, which involves bullying. Disclosure of intimate images or threats of blackmail can lead to mental health issues and even suicide among young people. This is one of the misuses of technology that the Cybercrimes Act aims to address, among many others. The Act was signed into law on the 26th of May last year by Ramaphosa, and certain sections became effective from the 1st of December last year, including the criminalization of data messages, in other words, text messages, WhatsApp messages, etc., that are considered harmful. It allows a victim of these types of data messages to apply for a protection order pending the outcome of criminal prosecution. Now, what's covered? Data messages of intimate images are covered in Section 16 of the Act. This section renders anyone guilty of an offense who intentionally discloses by means of electronic messaging service an intimate image of another person without their consent. It goes on to describe in anatomical detail the definition of an intimate image. The image may have been willingly shared by the subject, but that does not allow the recipient of the image to share it further. Section 16 states that it is an offense to disclose the image if the other person had a reasonable expectation of privacy at the time that the data message was made, and if the disclosure violates or offends the sexual integrity or dignity of the sender or amounts to sexual exploitation. Now, what can a victim now do? A victim of this type of cybercrime can lay a criminal charge against the other person with SAPS. This is covered in Section 20 of the Act, which allows a complainant to approach the court without giving advance notice. This is called ex parte, and apply for a protection order. The order prohibits the other person from disclosing or further disclosing the data message related to the charge. It also allows the complainant to order the electronic communication service provider whose electronic communication service is used to host or disclose the data message which relates to the charge to remove or disable access to the data message. When the protection order is granted, it is served on the cyber criminal if their identity is known, or on the electronic communication service provider if it is not. They then have 14 days to apply to court to set aside or amend the order. On the date the case returns to court, if the court is satisfied that an offense has been committed, it must order, number one, the person to refrain from further making available, disclosing, or distributing the data message. Number two, that the person or any other person to destroy the draft message, any copy of the data message, or any output of the data message, and submit an affidavit to the prosecutor that the data message has been destroyed. And an electronic communication service provider to remove or disable access to the data message in question. Now, if the perpetrator of the harmful message does not comply with this court order, they are guilty of an offense and may be liable to a fine or imprisonment of up to 2 years on conviction. Now, cyberbullying and abuse is a serious problem in our country, South Africa. It takes many forms, including harassment via social media. The Act has created a number of new offences related to data, messages, computers, and networks, and I welcome Section 16 of the Cybercrimes Act as a key means to tackle the harm done by abuse of electronic messaging. At my firm, Estee Law, if you are a victim of cyberbullying or have experienced the abuse of a data message, I can arrange a protection order against your assailant. Contact me on 086 099 5146 today for more information or to make an appointment. You don't have to suffer in silence. The Cybercrimes Act is there to protect you.